the state of Tennessee, and this honorable court. Please be seated. Good morning, ladies and gentlemen. We welcome you here to the September 2025 session of the Tennessee Supreme Court here in Knoxville. We also welcome those of you that are joining us by live stream. We're happy to have you with us as well. In just a moment, we'll begin the arguments in our cases. I would remind counsel each side will have 30 minutes for purposes of argument. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. Mr. Clerk, do we have any preliminary matters? No, Your Honor. All right, would you call the first case, please?
Kendall, Collier, ex rel. Chayce versus Periculis, Roussis, MP, et al.
Proceed.
Good morning. May it please the court. My name is Grant Llewellyn of the Knox County Bar. I represent Dr. Roussis. I will be arguing for 15 minutes. My colleague Rachel Hurt will have 10 minutes and will reserve 5 minutes for rebuttal.
Thank you.
And so we're here after a second jury trial in this case, and the issue for the court is what is the proper burden of proof for challenging the validity of a verdict for potential juror misconduct under Tennessee Rule of Evidence 606B. And so I think there is clearly direction needed from this court for the proper framework to apply and the proper burden of proof in this matter. So we would assert that the proper burden is clear and convincing evidence. That makes the most sense from a legal standpoint and also makes the most sense from a policy standpoint. But most importantly—
Mr. Llewellyn, let me ask you about that. Rule 606 precludes a juror from testifying about whether extraneous evidence had an influence or had an impact.
Correct.
Then how would you meet the clear and convincing standard without that?
Well, the Rule 606B does permit testimony on what information was presented to the jury, whether it's extraneous, outside influence, or for information about a quotient verdict. So that's what 606B covers, and so it would be the actual information that is conveyed, and then the admissible evidence would stop and not permit any further discussion on impact to juror deliberation, mental thoughts, process, that sort of thing.
But
well, I understand that's what it says, and the extraneous evidence that the jury considers is admissible, but the impact that it has is not. Am I right about that?
Right.
Okay. Well, then how does one meet the clear and convincing standard?
Well, I think that's what's important here is to incorporate into the burden this objective framework, such as the factors that we have in Adams, of let's take the information that we have admissible evidence on that was conveyed, let's consider the nature of it, the content, the number of jurors who were exposed to it, the weight of the evidence, and see what the ultimate potential impact of that information was on the jury deliberation process. And I think it makes sense for policy purposes of upholding jury verdicts. We had an 11, 12-day trial in this matter. We had 28 odd witnesses testify, over 10 expert witnesses. So I think finality of decision is an important policy factor. I think
finality of policy outweigh the constitutional right to a fair and impartial jury trial?
No, I think they can be consistently considered here. And so I think an elevated burden of proof, a higher burden, is consistent with both of those. And so if you apply an objective framework, you remove possibility from this equation. You remove conjecture and speculation, which you see a lot of in the Court of Appeals opinion, and you get to the heart of what was the information.
Well, what are you left with except conjecture if the juror can't testify about what actually happened in terms of impact? And I'm not questioning that policy decision, but what are you left with except in the mind of the judges who were making the determination thinking, how would I be impacted? I mean, That's what necessarily has to happen.
Well, and I
right?
think as an appellate judge or a trial judge ruling on this issue, you can weigh that.
It might be guided by factors and so forth, but that's necessarily the decision-making process that's going to happen, right?
I think you can weigh those factors without taking the ultimate step of this could have had an impact. This could have done X, Y, and Z, and so we're going to invalidate a verdict because of that. So in this instance, when you have two pieces of information that we have admissible evidence on that were both conveyed to a jury during deliberation, and we have extensive testimony from 8 expert witnesses all agreeing to both of those pieces of information, I don't see how you can get any kind of conjecture or speculation and arise to the conclusion that this was prejudicial or had an impact on the verdict.
You
Well,
would
let's-
be making that argument if it were a plaintiff's verdict and the extraneous information had been favorable to the plaintiff?
Well, here the extraneous information was not favorable to either side. It was uncontested. It was agreed to by
That was not my
everybody.
question.
So-
Would you be making this argument that it should be a clear and convincing standard if it had been a plaintiff's verdict and the extraneous information had been favorable to the plaintiff?
If the information based on the evidence presented at trial was discussed ad nauseum at trial and was favorable, then I would still be arguing for the same burden of proof.
What-
Because I think the legal framework supports that burden.
Like, when you look at the fact of coupling a clear and convincing evidence standard with the inability to obtain the subjective state of mind of the jurors, isn't that a really high burden that's almost impossible to meet for either party if they're faced with that type of a proposal?
I think it is a high burden, and I think we've set out in our briefing why a higher burden is supported by the case law and policy arguments. But I would also say for the objective framework that should be followed under Adams and under Patton setting up the threshold inquiry into this issue, I don't think it matters. I think under either burden, whether it's clear and convincing or preponderance, I think the ultimate guidance that this court could give to litigants and trial courts is how do we instill an objective framework that under either burden guides courts in this kind of determination?
Well, we've used a different burden in criminal cases for a long time. Why couldn't we put the same structure in place for civil cases?
And what would that look like? A higher burden for criminal cases?
Well,
lower-
there's a presumption of prejudice, and then that's can be rebutted by proof beyond a reasonable doubt.
Well, and some of the case law already, for juror misconduct, already anticipates that if you pass that threshold inquiry of extraneous, number 1, prejudicial, number 2, and had an impact, number 3, on the verdict, then you get that rebuttable presumption. I guess I would argue from a...
But can I interrupt you there for a second? You're saying that you only get the rebuttable presumption if there's proof that it had an impact? I mean, I thought the rebuttable presumption kicks in once it's shown that, and this is from Adams, our decision in Adams, that, the rebuttable presumption arises once it's shown that there was extraneous information presented to the jury and that it was prejudicial. And at that point, there's a rebuttable presumption that it influenced the verdict, which the non-movement has to overcome.
If you look at the cases that establish that threshold inquiry, which I believe starts with Patton v. Rose and is not contradicted by Adams, I think you have to have all 3 of those to get the rebuttable presumption. And so I guess that's where I would argue that, and then those Adams factors come in to determine if the non-moving party can rebut that presumption. I would argue...
I'm just going to point you to Adams. I mean, what Adams says is once the challenging party has made the initial showing that the jury was exposed to extraneous prejudicial information or an improper outside influence, a rebuttable presumption of prejudice arises, and the burden then shifts to this was a criminal case, so shifted to the state to introduce admissible evidence. So I'm not seeing, I guess, in Adams, which I think is the most sort of clear explanation of how this framework works, I'm not seeing how the moving party has the burden to show that it impacted the verdict.
Well, if you look at, I guess I would be relying more on Patton v. Rose for those three factors, but even if you follow under Adams, I still think the same analysis can apply. Is it extraneous? Is it prejudicial? I would argue here it is not prejudicial.
Well, it can apply, but it doesn't under Adams, but based on the language that Justice Campbell just read.
I'm sorry, I missed the first part of what you said.
I said it perhaps can apply if we were to say so, but in Adams, we said to the contrary, didn't we? Just based on that language that Justice Campbell just read.
Well, and I guess I'm arguing, instead of getting mired in the muck of whether there's a rebuttable presumption or not, you could fold the Adams factors into that initial inquiry of, was this extraneous information prejudicial to begin with? Because I think...
Well, I think the prejudicial inquiry is a bit, I think you seem to be conflating prejudice and impact on the verdict. And I think that, at least in Adams, the prejudice inquiry really just goes to, was this information that was favorable or unfavorable to the losing party, right?
Okay.
And, that's a different inquiry, I think, than whether it ultimately influenced the verdict. So you could have some information that was, prejudicial to the plaintiff or the defendant, depending on who the moving party is, but because of the overwhelming amount of other evidence, it wouldn't actually have influenced the verdict. So do you disagree with that?
No, I think there are three separate considerations.
Okay, but you would place the burden on the moving party as to all three of those?
I would, yes.
By clear and convincing evidence as to all three of those factors?
Yes, based on prior case law. But again, I think even if you fall under the preponderance standard, I still think the importance is an objective framework for analysis of, was this extraneous information prejudicial, and did it have an impact on the jury?
If we could go a little bit above what Justice Campbell just read in Adams, Adams says extraneous prejudicial information is information in the form of fact or opinion not admitted into evidence but bears on a fact at issue in the case. So this, as I understand it, was about the use of the epinephrine and the standard of care. So how does that not meet that definition of extraneous prejudicial?
Well, so the information conveyed verbally by the juror was that he looked at the warning on an EpiPen, and it says that caution should be used if the recipient of the EpiPen is pregnant, and that should only be used if the benefits are outweighed by the risk. So evidence not admitted at trial, it doesn't fit that definition because that evidence was admitted multiple times at trial.
But it wasn't admitted in the form of the manufacturer's warning from the box of the EpiPen. It was admitted through testimony of the expert witnesses, correct?
Correct, and two of those expert witnesses testified specifically to the warnings on drug literature. So the EpiPen warning would fall under that category, and both those experts were plaintiff's experts.
So
And
you're
under 618, Rule of Evidence 618, we couldn't admit the actual drug warning label in and of itself anyway.
So you're wanting us to follow Patton more so than Adams. Is that your position?
I don't think they're contradictory. I think they are consistent with each other.
Well, Patton is a court of appeals decision,
Yes.
correct? Adams
Yes.
is a decision of our
Yes.
court. Is there
Correct.
Adams is a criminal case, but is there any distinction between criminal and civil cases that you think warrants the application of a different standard?
I don't think so, because I think
I'm not sure how you can argue that, especially based on the language that I just read you from Adams, how you can say that that is consistent with, I think, your position that the burden remains on the movant as to all parts of the inquiry. And to the extent you're gleaning that from Patton, I think Patton is inconsistent with Adams.
Well, I think even if you take that third factor out of Adams and just consider extraneous and prejudicial, I don't have a problem with that either, because I think, at least for purposes of this case, you end at the prejudicial question regardless.
So did I understand you to agree that we ought to be setting the same standard in civil and criminal cases for this issue?
I mean, ultimately, that's Your Honor's decision, but I don't see any problem with that, because I think the elevated burden on the front end of the trial takes away that concern.
Well, and that's consistent with common law, is it not?
Yes.
To treat those similarly? Well, if we're treating them similarly, then are you advocating that we change the criminal standard? Because if we're to take your position and we want to have the same standard in both cases, we'd have to change Adams, would we not?
No, I don't Adams doesn't mention a standard or a burden.
Well, it doesn't, because it creates a presumption.
Well, and I think the presumption is aside from which ultimate burden of proof is utilized. I think they're consistent, but not at odds with each other. So I think the burden is one thing, and then how to navigate this rebuttable presumption it goes along with that, but I don't think one necessarily has to change the other.
So I understand, may I ask one more question?
Yes, question.
If I understand you correctly, put aside for a moment the burden of proof, assume that it's something like preponderance of the evidence instead of clear and convincing. So if we essentially have a standard in civil cases that requires the movement to show that the information shown to the jury was both extraneous and prejudicial, and establish at that point a rebuttable presumption that it also impacted the jury, and then the non-movement has the burden of showing that it would not have. Is that consistent? Are you saying with what would be a reasonable standard?
I think so.
Okay.
And I think under that standard, we don't get past that prejudicial, and obviously don't get
I understand, under the facts in this
under the facts
case,
in
you're
this
saying
case.
this wasn't even prejudicial.
But I would agree with your analysis.
Okay.
Thank you, Mr. Wong.
Thank you, Your Honors.
Ms. Hurd?
To shorten that. Good morning, Chief Justice Bivens, members of the court. I always make prepared statements and then I immediately pivot, and I'm going to do that right now. I want to respond, Justice Kirby, to exactly the question you've just asked. If you take exactly the standard you've just said should be the standard, if we accept that to be the standard, in this case, under these facts, the outcome, the validity of the verdict, which is the caption of Rule 606B, the validity of the verdict is unquestioned. And I want to explain that and go and discuss that. Certainly, the trial court, Judge Ayler, and the Court of Appeals said that the analysis, the burden of the moving party is unclear based upon the case law. I'll stand here to say that's a policy decision of this court, whichever way this court goes. In civil cases, all litigants going forward want clarity. Accepting that the standard of proof, the burden of proof of the moving party is a preponderance. In this case, this was not prejudicial. This wasn't even extraneous. It was offered in the court 8 times by 8 experts. I'm going to know more about softball than I'm ever going to know about the law. 8-0 is a run rule. The Court of Appeals said this was a tiebreaker, potentially a tiebreaker. It was 8-0. And if you look at, and the only thing I have here to really discuss, if you look at what the juror affidavits say, and then compare it side by side, which is what I've done, to the testimony that was offered in this court. The juror affidavit, the EpiPen stated caution should be used during pregnancy. That was statement number 1. James Wedner, plaintiff's allergy expert, was asked the question, and there are concerns reported in the drug literature, to go to Justice Wagner, to the drug literature. First of all, you should only administer epinephrine with caution in pregnancy. Caution in pregnancy, answer correct. Exactly what the juror affidavit says. Caution should be used during pregnancy. James Wagner agreed. Bruce Bryan, plaintiff's expert, primary standard of care expert as to Dr. Roussis.
If I could interrupt you there for a minute. My understanding is that plaintiff's experts, while there may have been statements to that effect, plaintiff's experts also testified that if you do sort of a cost benefits analysis of, administering this drug, even in pregnancy, you're really, that analysis is always going to tell you to administer the drug. That there is no situation in which, the costs would outweigh the benefits, even with a pregnant woman.
Yes, Your Honor.
And if that's the case, isn't the fact that the jury became aware that this label was actually, was on the epinephrine, doesn't that lend, call into doubt, whether the plaintiff's expert's testimony, saying that there would never be a situation in which you wouldn't administer it, doesn't it call that into doubt, or at least give a little bit more weight to the view that, there could be a situation where you don't administer it, which would obviously support defendant's position? I see what you're saying, that there were these other statements in the record, but I think that glosses over the totality of the testimony that was presented by the plaintiff.
So I think the jury reached the conclusion because they heard the testimony that it was undisputed, what the label said, what the warnings were. Both sides agreed to that. But the ultimate issue that the jury answered was, even with that label, what was the appropriate treatment? And the jury in the trial court as 13th juror, after listening to 25 witnesses, 12 experts, concluded that Dr. Roussis was within the standard of care to make the decision that he made. So I believe, but if the initial inquiry question for this case is, was it extraneous and was it prejudicial, it didn't go to the ultimate issue that the jury had to answer. Did Dr. Roussis follow the standard of care? It was undisputed by both sides. My analogy, I thought way too much about this. My analogy is this. A juror in a car wreck case drives through the intersection where the car wreck is. He comes back to the jury the next day and says, hey, there's an intersection. There's a light at that intersection. The jury says, we know that. The question is whether it was red or green. The same is here. It's undisputed that there was a warning label. It's undisputed that it said caution with pregnancy. It's undisputed that the potential benefit has to weigh the potential risk. Bruce Bryan, again, plaintiff's expert, said that's true of all medications. With all medications, you give with caution, you order with caution, and the benefits have to outweigh the risk. The juror didn't need to come in and say...
Do all medications have a label to that effect, though, specifically to use caution in pregnancy?
I'm not going to speculate. I've been pregnant twice, and I reviewed...
If that's not in the record, don't tell me.
I reviewed everything because I was very concerned about that myself. I don't know that answer. I'm sorry. I don't want to make an assumption.
Well, I again want to sort of take you back to this potential conflation of, whether the information is kind of prejudicial in a more general sense and whether it prejudiced the verdict, because I do think that those are two separate inquiries. And what you were, a moment ago you said that it really didn't go to the ultimate issue that was before the jury, so it wasn't prejudicial. But couldn't information be, if it went to any issue that was before the jury, wouldn't that make the information prejudicial under that kind of first part of the analysis, where you're looking at whether the information was extraneous and whether it was prejudicial, setting aside the burden shifting and sort of whether it ultimately influenced the verdict?
Yes.
Could you explain why, in your view, it's not prejudicial kind of in that first, what would be the second step of the analysis?
Yes, Your Honor. And I did think about this because it is a three-prong initial threshold that's talked about in the Booker case that is kind of referenced in the Adams case of this court, that there are three threshold. In the middle is prejudice, and the third is it had an impact, which goes to your point that I think that is two different inquiries. The book that I like the most talks about the definition of Rule 606B as the validity of the verdict, and it states, the term validity suggests that Rule 606B applies to testimony that attacks the verdict as well as supports the verdict. And so the prejudicial inquiry is twofold. Everything that a defendant should say at trial is prejudicial to the plaintiff. Everything that plaintiffs should say should be prejudicial to the defendants. So if that's the initial inquiry, was it prejudicial? All parties agreed to this. And so it doesn't even meet that initial threshold of prejudicial as you're describing. And then did it have an impact on the jury? And that answer, under either standard by a preponderance, that burden was not met. by the plaintiffs.
I'm sorry, go ahead. No, go ahead.
Counsel, would you agree that the appellate court should review the decision by the trial judge on an issue like this under an abuse of discretion standard?
I do, Your Honor, and that's the last bullet point I have to make.
Well, then let me ask you this. I heard you say, if I heard you correctly, when you started your argument, that you agree that we need to clarify what the standard is, and because it is kind of all over the board, correct?
Yes, Your Honor.
Well, if that's the case, and we do that and set a new standard, would we not need to send this back to the trial court and let the trial court exercise its discretion based on the new standard we adopt?
I have a two-part response to that, Your Honor. The answer is I perfectly believe that this court can remand to the trial court. What I would ask the court is to look at Judge Ehler's April of 2022 order. He says the law is unclear. He does discuss a clear and convincing evidence standard, but his analysis of those 3 threshold inquiries, he says unequivocally this did not have an impact on the jury. Unequivocally. Not like the Court of Appeals and to Justice Kirby's previous statement about conjecture. The Court of Appeals said the statement could have swayed the jurors. The Court of Appeals opinion said it could have accorded undue added credence. The jury could have viewed the warning as a tiebreaker. Could have. And the ultimate final paragraph, it was a reasonable possibility that the verdict could have been different. That's a possibility of a possibility. And under an abuse of discretion review, which is what the Court of Appeals was to do, they reversed the trial court who sat through 12 days of testimony on a possibility of a possibility. And that can't be the standard. Anything is possible. This court has said that in Kilpatrick versus Bryant. That was under a causation standard. But anything is possible. If it's possible that it did, it's just as possible that it didn't.
So is the trial court assessing whether a reasonable jury would have been impacted or this particular jury? And I ask that because on appellate review, that affects how we frame it and whether we have to remand it to the trial court or whether we can look at the evidence and determine whether a reasonable jury would have been impacted.
I really appreciate that question because I think it's a great one. The case law says it's a reasonable jury. The distinction here is this jury was in the room. This is the jury that decided this case. This is the jury that sat there for 12 days. This is the trial court who reviewed that jury's verdict. It is this jury and whether they were impacted. If the inquiry is the validity of the verdict, it's the validity of this verdict. While litigants going forward clearly want clarity on this issue, for the purposes of the litigants here today, may I keep going? Can I finish? For the purposes of the litigants here today, it was this jury and Judge Ehler found that they were not and could and were not, and I don't want to say could not because that's probable, they were not impacted because this was not prejudicial. And we asked the court to look at the record as a whole, to look at the experts and what they stated and find that this was not prejudicial information and it did not impact the jury.
Thank you.
Thank you. Mr. Bednarz?
Good morning.
Good morning.
May it please the court. I am Joe Bednarz, Sr. of the Nashville Bar, and along with my son, Joe Jr., we have represented Ms. Collier in both trials and in both appeals. But a lot of the questions that the court has already asked were really answered early on by Judge Ehler. When we submitted these affidavits to the judge, even without argument, he granted us a new trial, just based on his research, the affidavits, and the law as he read it. The defense moved and asked for him to reconsider, and they argued the Whiteside case, the Mayo case, these Court of Appeals case that discuss clear and evidence. And Judge Ehler, after several arguments, actually told us he thought that 606B allowed us to get affidavits. And he told us to get more proof because he wanted to know what the jurors were thinking. Well, of course, we couldn't submit more proof because 606B prohibits it. So we went back to the court, explaining we can't get affidavits, they're just not authorized. So once again, he took it under advisement. Now, he made the statement, this information clearly had to affect the jury. I mean, he specifically said that. It had to affect the jury, but you didn't carry a burden by clear and convincing evidence. So he was relying on Mayo and Whiteside.
And is it your position, Mr. Bednarz, that the clear and convincing standard applies?
Oh, it does not, no. Clearly it does not. I think the law, I'm not an appellate lawyer, I'm a trial lawyer, but as I read Adams and Walsh, I think it's pretty clear. I think the guidelines are there, the factors are there, and we obviously have the burden to prove initially that it's extraneous and prejudicial, but when you look at at the definition of prejudicial, we've clearly met that burden. That is so obvious.
All right, well, let me ask you a follow-up,
Sure.
and I bet this is something that you and I agree on. Our jury system is sacred, right?
Yes,
It's the best in the world,
absolutely.
and juries tend to get things right, usually, almost always, at least in my experience. Given the honor and the sanctity of our system, why should we not apply a clear and convincing standard in cases like this when extraneous conduct is introduced?
I certainly agree. I think it is sacred. We've got no business going into the mindset of jurors asking them these questions. And I think 60B has been clear. It's been the law, I think, since 1898, the way the federal courts, I think there was a case called Maddox. But we showed that when we argued this at the Court of Appeals, Judge Sweeney, who I submit wrote a very good, detailed opinion, well-reasoned. There's no way I can improve on any of the arguments and issues that he covered in that opinion. But I lost my thought trend there.
Well, let me redirect you a little bit then to
Yes,
follow
okay,
up
thank you.
on that. You're talking about the Court of Appeals opinion. Doesn't the defendant have a point, though, that opinion was filled with essentially conjecture as to how there could be prejudice here? Could have been this, could have been that, could have been that. Is that really the standard that we want appellate courts to be doing, to speculate as to what the potential prejudice was?
No, I don't think that's it at all. If you follow,
Isn't that what the opinion did?
well, I don't know. I certainly didn't read it that way, Judge. I think when you see, they're taking a position that this information had been covered at trial and that it was, in essence, harmless. Well, it wasn't harmless. The issue was so clear. We had 4 experts from very good institutions, the University of Missouri, North Carolina, all well qualified, to say you always give epinephrine for a severe anaphylactic reaction. Always,
But
always,
is
always.
it, just putting aside for a moment what our standard should be, I've been thinking about this in terms of if the label had been shown at trial. In some of the testimony about what the label said and so forth, the witness said, here, it's right here, it says. And I thought, would that have been harmless error if there had been testimony about the label and what it said anyway? If it's framed in that way, how should we think about it?
Well, I don't think we could ever get the label into evidence.
I understand that. Obviously, that would be an error. You'd have
We can't use medical
all the motions
literature
associated with
yes.
that, yeah.
Well, it would still have a factor because you've got 4 experts saying you always use it. you've got this label that says you only use it with caution. So that goes in favor of Dr. Roussis and what his experts are saying, that it's a judgment call. You should always weigh the risks and benefits. So this was a critical issue. Mr. Jacobson couldn't make up his mind, obviously. He went and done his own research. This is like another expert testifying, an unpaid expert, but with impeccable credentials. They made the product. They made the product, and they were siding with the defendant's argument. And that's why it was so prejudicial, even if it had been discussed at trial. When you get something from the manufacturer coming in.
I think what my mind goes to is, was it just cumulative, essentially?
Yeah.
Did it just amplify? That I understand that was the big issue at trial. Your experts said, you're going to always give this drug. Their experts said, not so much. And it went to the not so much side. But was it essentially cumulative under the circumstances?
I'm sorry, what?
Was it essentially cumulative of the defendant's
No, it was not cumulative.
testimony?
That evidence
Okay.
did not come in.
All right.
That evidence did not come in.
It put a real, I do understand that it didn't come in as evidence. I'm just trying to figure out how should an appellate court look at whether there was actually impact on the jury. And that, I guess that goes to the next question. Does that decision have to necessarily be made by the trial judge because he or she will have seen that jury, or does the appellate court think about it in terms of whether a reasonable jury would have been impacted?
Well, of course, it's always made by the trial judge when you have misconduct, at least initially, and it's usually resolved at the trial court level. But sometimes it's not resolved properly, and we end up at the Court of Appeals and here at the Supreme Court.
And he sits as the 13th juror,
Yes.
and he didn't see the EpiPen, right?
I'm sorry, Judge.
He was not privy to the information
Oh,
about
no,
the EpiPen.
absolutely not, no.
Right, and so what do we do with that? He's the 13th juror. He upholds the second adverse verdict that you against this man, or do we consider that?
Well, I'm sure there are two separate issues. He upheld it as 13th juror, but he also set it aside based on misconduct. And so I don't know how you reconcile both of them. I don't think upholding is, if you allow the trial judge to uphold a misconduct by virtue of the 13th juror, you would be giving him undue power and undue authority to do that. I mean, the misconduct is usually very, very prejudicial to one side or the other.
But you just said he set it aside. Well, the trial judge only set it aside initially and then reconsidered, right? Because ultimately he did not set it aside.
Could I'd like to ask you a question about Rule 5907, Rule of Civil Procedure 5907, which gives the court authority in some circumstances to grant a new trial. In that rule, it says that a new trial may be granted to all or any of the parties in which there has been a trial by jury for any of the reasons for which new trials have heretofore been granted. So that language at the beginning of the rule seems to be discretionary. It's that a new trial may be granted. What is your argument as to why a new trial, I guess, must be granted in this case? And how do you read that Rule 5907 to just give the court discretion? And I guess if so, in what circumstances would our case law or other sources of law require that a new trial be granted?
I haven't thought about that, Judge, but I don't see where Rule 59 would come into play in this situation at all. I don't think, the issue is the misconduct.
Well, the misconduct is what provides a ground for granting the new trial, right?
Yes.
Did you argue that this misconduct violated your client's right to a jury trial?
Not in that way, no, Your Honor, we didn't. We argued that we didn't get a fair trial and that it influenced the verdict, which we think it clearly did, certainly as to Mr. Jacobson. He was the one obviously undecided. They go home for the weekend, and he's looking at this, and I do think the Court of Appeals was right. This was kind of a tiebreaker because now you have literature that sides with the defendant, not the plaintiff.
And so your
Literature,
argument,
you've-
sorry.
I'm
Go
sorry.
ahead.
You've actually got a government warning on a product, right?
Yes.
And so
So
you-
on the framework for the analysis, I'd like your comment on that framework. Assuming that we do not adopt a clear and convincing standard, an Adams-like framework where the movement shows that extraneous information was introduced to the jury, the movement shows separately that it was prejudicial, and that sets up a rebuttable presumption then that there was impact on the jury from the extraneous prejudicial information, and the non-movement then has the burden of rebutting that presumption. I'd like your comment on that structure.
Yes, Your Honor, and I think Adams is really clear-cut. We have to prove initially extraneous and prejudicial. They define prejudicial, not as the defendants have defined it, but their definition of prejudicial at the first stage is information in the form of either fact or opinion that was not admitted into evidence, but nevertheless bears on the fact at issue in the case. We carry that burden clearly. It is so obvious that information was not presented at trial. It was not at all. So once we prove that, the burden then shifts. There's a presumption of prejudice, and the burden
A
now
presumption of
shifts.
impact, right? I mean, there's difference between prejudice and impact. The rebuttable presumption is that it would have impacted the jury's decision.
Let me say, well, they have the duty then to rebut the presumption of prejudice. And of course, in this case, they haven't done anything, to try to rebut that presumption. But I think once that shifts, and then the criteria according to, excuse me, according to Adams, is that is there any possibility that it could have affected the verdict? That's the standard, I think, that is implied or put forth in Adams. They have the burden of proving that there's no possibility that this
Well,
affected the verdict.
All right, I mean, the ultimate burden is on the movement, right?
No, the initial burden of proving extraneous prejudicial information is on me, is on the plaintiff in this case. But once we've proven that, then it shifts to the defendant or the appellee or the appellant in
So
this
how
case.
is that, and I'm thinking out loud with you, how is that really fair to ask the movement only to show that it was extraneous, only to show that it was prejudicial, which essentially means it kind of favored one side? How is that fair overall to then remove from the movement the burden of proof and put it on the non-movement?
Well, misconduct of the juror under these circumstances is so severe, I guess that's the whole idea of it.
Severe, I mean, what does that mean? It only has to be a little bit prejudicial to meet the standard that I articulated. So how
Then
is that
shift the
fair
burden.
then to completely shift the burden from the movement at that point? It's off his shoulders. It's on the non-movement to essentially prove a negative. How is that an appropriate structure here? Because we have not applied that structure in civil cases. We've got a clean slate on that.
I don't think I can answer that, Judge. It's, I think that one's above my pay grade on it.
Okay.
But
Counsel, I think you said a moment ago that the burden on the movement would be to show that there was not any possibility that it could have affected the verdict. But isn't it really a kind of a more probable than not standard? I mean, if we're applying a preponderance of the evidence standard, wouldn't we ask whether the non-movement had shown that it was it more probably than not would not have affected the verdict? I mean, the any possibility standard seems to be a very low bar, as opposing counsel has pointed out. I mean, is that really what you're arguing for, or is it preponderance of the evidence and your position is just that that hasn't been satisfied here?
I'm used to living with preponderance of the evidence on all issues. So, preponderance of the evidence would be fine, but I think there are policy considerations for protecting the sanctity of the jury, which they have to respect, and therefore they allow things like this where we just can't prove it. We've either got to go to the jury and get them to testify, how did this affect you? Or we've got to have some standard that is reasonable to prevent misconduct and to help ensure fair trials. So I think it's a compromise that the courts have developed over the years, but
would you agree that it's not enough that it might have affected the verdict? That it has to be that it was at least a little bit more likely than not that it would have affected the verdict?
that makes sense, but I don't think that's the law.
And what do you point to for that? I mean, why don't you think that's the law?
Well,
Can you point to?
I think Adams and Walsh both clearly articulate that it goes to whether or not there's a reasonable possibility that affected the verdict. I mean, that's what the case law says. And in fact, those four factors that they lay out are designed to help a structure or a format to determine whether or not there's any reasonable possibility that it affected the verdict. So, I mean, that's the standard, and at least as it is now. And
So help me, I don't want to hyper-focus on this issue, but I am focused a little bit on, as you can tell from my questions, a little bit on whether the assessment is made as to this particular jury or a reasonable jury. And what's sticking in my mind is that we can't have evidence of the actual impact of this jury. We can't have juror testimony about it. So how can you do anything other than assess using the factors whether it would have impacted a reasonable jury? And that affects how the appellate court reviews the trial court's decision.
Yeah, that's a question that, I hate to say it, but it's above
And
my
yet
pay
I asked
grade.
it anyway, so.
It's,
All right, I'm giving you the opportunity to comment on it.
Well, my son, who is far more up on these things than I am, the reason we have reasonable possibility, as stated in the cases, is because we cannot ask questions of the jury to prove it had an effect. And it's almost an impossible thing. If we have the burden of proving that it affected the jury, even by a preponderance of the evidence, how could we do that?
Well, I mean,
do it.
in the context of, for example, harmless error, whether a defense lawyer, a criminal defense lawyer's bobble what was harmless error or not. We have to make that assessment, and we assess it as to a reasonable, whether a reasonable jury would have been affected by that.
Well, you know, some of those cases, Judge, that I've read that have misconduct, you can just read the record and see there's no way it could have impacted the jury.
Sometimes it's very
Absolutely
clear,
no way.
sometimes it's not.
Yeah, but in cases like this, where that's the central issue, people on both sides, you can see that it probably did. Or there's a really good chance that it did, even if it's one juror, even if it's Mr. Jacobson.
Well, if I understand what you're saying that because we can't have juror testimony about actual impact, you have to have a very low standard, whether
Yeah,
there's any
I
reasonable
think so,
possibility.
That's what I think, yes.
Let me ask you the same question I asked Ms. Hurt, and that is with regard, if assuming that an abuse of discretion standard does apply to the trial court's consideration of the juror misconduct issue, if we adopt a new framework here and clarify what the framework ought to be, should we not remand this case to the trial judge and let the trial judge exercise his discretion based upon the new standard we adopt?
Boy, that's a tough one. In this case, I would say no. You know,
Why
Judge
do you say
Ayers-
that? I'm curious about Justice Bivens' question, too. Is it your position that you get a new trial?
Yes,
Or
Your Honor.
that's your position?
Yes.
Okay, not to remand it for Judge Ayler to apply the correct standard?
Right, Your Honor. I think as the law exists today, and I think Judge Sweeney did an outstanding job of laying it out with reasoning, and they granted us a new trial. I think this court ought to appel it, and it's consistent with the law as it is, certainly.
Well, what if we say the Court of Appeals got it wrong?
Well, then it has to go back to the trial court, I guess, if the Court of Appeals got it wrong. Or this court can exercise its authority and decide those issues. I don't think it has to go back to the trial judge. And I say that.
In order for us to do that, under Justice Bivens' scenario, if it's an abuse of discretion standard, we would have to show that the trial court's decision was not even in the range of the reasonable decisions that could have been made.
Well,
That's a
I think
high standard.
some things that are important is Judge Ayler initially granted us a new trial.
Well, now, how is that important, Mr. Bednarz? You've mentioned that 2 or 3 times. Once that decision is set aside, which he did, he clearly set that aside, correct?
Yes.
Then how can we rely on that first order in any form or fashion?
Well, I don't think you can. You know,
Well, but it
because
sounded like
they
you were
went
trying
in-
to argue, you've tried to argue 2 or 3 times that we should.
Well, I think what's important is he stated it had to affect the verdict. Now, that was his opinion. I mean, that's his opinion, that this extraneous information had to affect the verdict. I think that's important for this court to consider. But if you send it back, Judge Ayler obviously struggled with this. He granted us a new trial, set it aside, and then he sat on it trying to figure it out for 2 years. He had it under advisement. And to send it back to the trial judge and put the monkey on his back to decide the issue, I don't think would be fair to Judge Ayler.
Well, that is a practical problem in this case. Judge Ayler's had a few things in the interim, and so if he is assessing how it would have impacted that jury, he would have to have a mighty sharp memory to go back now, at this point, probably 3 years later, and remember this particular jury.
Mr. Bednarz, could I ask you a question about the abuse of discretion standard of review? I mean, that standard of review it's kind of a funny thing, right? Because it sounds very deferential, but then when you actually look at what all of the different decisions that a trial judge makes, there are a lot of decisions that are kind of subsidiary to the ultimate conclusion that even under an abuse of discretion standard would still be reviewed de novo. So for example, the trial court's legal conclusion, the conclusion on an issue of law about whether the information was prejudicial. That, to me, seems to be a question of law that would still be reviewed de novo, I guess, even within the abuse of discretion standard. So I guess what I'm wondering is, what exactly does the trial court have discretion about when it comes to this determination? I mean, a lot of these issues really do seem to be ultimately issues of law. So is there any piece of this decision that is discretionary such that an abuse of discretion standard would apply to that particular piece of the decision?
On misconduct, as I read it, I don't see where he has a lot of discretion. I mean, that law is pretty clear. I don't see the discretion there.
And so if these are, I guess if all of these conclusions that are part of the ultimate decision are really legal issues that would be reviewed de novo, would there be any reason to remand?
I'm sorry, Judge, I'm having trouble hearing. My hearing aid's broken, they're gone for a week or so.
Well, that was bad timing. My question is just, if these are all really issues of law that are reviewed de novo, then would there be any reason to remand?
Any reason for what?
For a remand.
I can't answer that, Judge. I just don't feel qualified to answer that question, to understand how it would impact everything. But anyway, I've already heard some criticism or some doubt about the Court of Appeals opinion, but as I see it as a trial lawyer with limited knowledge of appellate law, that argument that was set forth by Judge Sweeney seems to be very accurate, on point, and really tells the story. And I don't think I can improve on the argument. And but I do think, from my viewpoint, I think Adams is pretty clear-cut and gives guidance for the subject matter.
So I'd like to give you one last shot while you got a yellow light on here. Let's say we agree with you that Judge Sweeney applied the right standard, that the preponderance standard. Tell me why, as best you can, point by point, why this particular situation impacted the jury. Why did, even under a preponderance standard, did this make a difference?
Okay.
Such that this verdict, your second loss,
Okay.
should be set aside.
Yeah. Because you had, the issues were so clear-cut the way the experts lined up. For mine, saying you always give epinephrine, no exceptions. You have Dr. Roussis and his experts said, I evaluated the situation and used my judgment. And I decided I did not have to give it and shouldn't give it because her blood pressure hadn't dropped. So you've got these opposite opinions, and then you have the manufacturer who made the product saying, in pregnant women, you only use it when the benefits outweigh the risk. So that puts, that's in favor of what the defendants are saying, that he weighed them and made a judgment call. And that's why it's so crucial. And it's coming from the manufacturer. It's like expert testimony. We have no chance to cross-examine it at all. And that's why it's important, and that's why we believe it was very prejudicial.
Thank you, Mr. Bednar.
Thank you.
Ms. Hurd, I've always found you to be a very helpful lawyer, so I would like for you to help me now. If we agree with you that the clear and convincing standard should apply, speaking in the abstract, tell me what kinds of evidence would meet that standard, since Rule 606 precludes testimony about how the extraneous evidence impacted the jury?
Your Honor, I think that's a difficult question. I think that the preponderance standard is easier, and given the 13th juror role, that 50.1% is an easier standard to demonstrate. Clear and convincing, as we're arguing, is strictly from appellate decisions, and that's why we're asserting that. But I think that is a difficult burden. Not saying it shouldn't be the burden. If we truly believe that the jury verdict is sacrosanct, that it has meaning and it has purpose, not giving up the constitutional right, but if it has meaning and purpose, and we want to believe that the jury gets it right, that's why the clear and convincing, it's a policy decision that clear and convincing should be the burden. But I understand and respect your question.
Let me follow up. I asked your co-counsel if he agreed that at common law, civil and criminal cases were treated essentially the same in this area. Would you agree with that?
I've put some thought into this, and I understand the burden is clear and convincing in criminal court, which I'll, good Lord willing, never practice. And so it's too easy to make the assessment that clear and convincing is the burden, so clear and convincing should be the burden in criminal. Preponderance is civil, preponderance should be the burden in civil. But I don't think that gets to the policy decision. The policy issue is the bigger issue.
Well, but let's get back to my specific question is, at common law,
Yes.
historically, have we not treated the civil and criminal cases essentially the same for purposes of an issue like this?
Well, the case law would kind of diverge on that. There's been some crossover, certainly in the Mayo case.
In our court?
In your court, no, Your Honor, it's been identical.
Okay.
I would agree.
If that's the case,
Yeah.
then can you tell me where anything from our court was adopted or the legislature to alter that common law from today's case?
No, Your Honor. And if the court sticks with the common law, as I've stated already, the court sticks with the common law, the court sticks with Adams, the court sticks with what it's always done, we still win. And that's really the position, that under the preponderance standard, defendants still win.
Ms. Hurt, can you answer, I guess, the question that I posed to opposing counsel about the abuse of discretion standard of review?
Yeah.
I mean, would you agree that legal conclusions are still reviewed de novo even within an abuse of discretion standard?
Legal questions are, but to your question earlier about Rule 59, the citation is to Pivnik. And Pivnik talks about these types of issues, which are abuse of discretion standards. The Rule 606 analysis is abuse of discretion. How the
Rule
trial court...
606 just has to do with admission of evidence. I mean, I know some of our opinions, I think, have some loose language about this being really a 606 inquiry, but it's not. I mean, 606 is a rule of evidence.
Right.
That does not go to the ultimate question of whether a new trial should be granted. 606 just has to do with the evidentiary issue of whether certain evidence should come in. So we're not reviewing, I mean, this really has nothing to do with 606. Would you agree with that?
I wouldn't for this reason, Your Honor. I'm looking at the caption, I know that's not binding, but the inquiry, it inquires into the validity of the verdict. The trial court looks at the testimony, looks what was heard, and then as 13th juror makes a decision, but also under this analysis on a motion, a new motion, in this case on juror misconduct, he's weighing the evidence, or she is weighing the evidence, and that is an abuse of discretion standard. Now, if the trial court...
So what specifically, I mean, that's what I'm curious about, like what exactly... What part of the trial court's decision is really a discretionary decision, not a legal conclusion?
If you're weighing facts and deciding whether by preponderance of the evidence or clear and convincing that it impacted the jury, the third prong of the Adams analysis.
But isn't that typically a legal conclusion? Like in the criminal context, when we do a harmless error analysis, I mean, that's a legal question that gets reviewed de novo, you know, whether an error was harmless or not. So what's different about that part of the framework that makes that discretionary rather than a legal conclusion?
The same way that a trial court rules on objections, evidentiary issues, those are reviewed by the Court of Appeals on a discretionary standard because it's the court weighing those factual issues on rules of evidence. This is a rule of evidence too, 606.
Well, but I see your time's expired. Could I ask one follow-up question? When you say this is an the only, I guess, way in which this is an evidentiary question is, kind of weighing the evidence. But that doesn't go to 606. 606 is just about what evidence is admissible. Whether you can admit, the jurors' own deliberations and their own impressions about the deliberations. I just don't see this as a 606 issue.
May I finish?
Sure. You may answer.
Yeah. If I understand the question, 606 is a rule of evidence, and the way that the courts, including in Adams, have looked at that 606 analysis by applying the threshold, they've looked at the trial court's ruling on an abuse of discretion standard. What I think you're saying is it should be a de novo review, which may go to justice.
Well, it's abuse of discretion, but I guess within that, if a court makes a legal error, that is an abuse of discretion.
I agree. I think it's a mixed question, and to his credit, Judge Sweeney does talk about that there's a mixed question on the standard. The standard to be applied is a question of law, and that is a de novo review. And on a de novo review, if the wrong burden was applied, the court could remand or review de novo what the burden should be. Here, though, the trial court, while he talked about this clear and convincing standard, he unequivocally found under either burden that there wasn't prejudice and it did not impact the jury. And so I think that's where I'm going to. The Court of Appeals reversed on a possibility of a possibility, a decision of the trial court, and the plaintiff attorney wants to criticize that it took 2 years. This was 2,800 pages of transcript. I'm glad it took him 2 years. He gave it a thorough review. And under his discretion, having heard the testimony, under either standard, he found that it did not impact the jury. And that's the ultimate inquiry. Regardless of the policy decision made by this court, the ultimate inquiry as to these litigants, not future litigants, is that it didn't impact the jury.
Can you help me out? You've said multiple times that the trial court found that it didn't have an impact on the jury. Sorry, I'm not in front of the microphone.
My hearing's good.
The plaintiffs have cited in their brief a transcript where he said it had to have had an effect. So how do I rationalize those two statements?
Yes, thank you. These were part of my notes. I wanted to answer that directly. Plaintiff entirely wants to talk about orders that were not the final order. That was not the order appealed to the Court of Appeals that's now on appeal to this court. The trial court speaks to its final orders. And his final order doesn't make that. He made a mistake, and he corrected it. He got it right the last time. And we're appealing the last order, not previous orders.
All right. Thank you, Ms. Hurd.
Thank you, Your Honor. May we be excused?
You may, and we'll stand in recess briefly.
Oh, thank you. I never got to a single note.